Now let's go to the principle of arrest. Rule 113. Arrest is simply defined as the taking of a person into custody in order that he may be bound to answer for the commission of an offense as provided in Section 1, Rule 113. The requirement as to the making of arrest under Section 2, a person need not be actually restrained by the person making the arrest. Under the rules of court, a submission to the custody of the person making the arrest already constitute an arrest. Whichever means is used to make an arrest. The term necessarily implies control over the person under custody, and as a consequence, a restraint of his liberty is to the extent that he is not free to live on his own free will. So, by the moment a person is restrained from his liberty, he cannot move by his own free will. He cannot leave the place by his own free will. Then there's already what we call an arrest or taking into custody. Sir, what is the limitation or when force is necessary? Well, the rule is that no need for the application of actual force, manual touching of the body, or physical restraint, nor formal declaration of arrest is required for arrest to exist. It is enough on the person of one of the parties to arrest the other, and there is an intent on the part of the person to submit under the belief and impression that the submission is necessary. So there is no need for the... Sir, is there a need for the accused to be handcuffed when in fact he has already voluntarily surrendered? Well, that's the standard operating procedure that the accused must be handcuffed for security reason. Now, what is the rule as to the issuance of warrant of arrest? Under Section 2 of Article 3 Bill of Rights, no warrant of arrest shall be issued except upon probable cause to be determined personally by the judge after examination under oath or affirmation of the complainant and the witnesses he may produce, particularly describing the person to be arrested. It is thus the requirement of warrant of arrest shall issued only upon finding of probable cause to be determined personally by the judge. So delegation is not allowed. For example, sinabi niya, magaling yung clerk of court niya na lawyer. He's been a legal researcher for 5 years and he has been well-known and he already has received what we call Judicial Excellence Award as a legal researcher. Okay, or he received an a number of flack of appreciation from the court or other entities. That is not allowed. Delegation is not allowed. Why? Because the law says, or the rule says, there must be personal examination or determination by the judge. Sir, what is meant by personal examination by a judge? Well, that is the requirement class. While it seems to appear that the Constitution required examination, or the judge to personally examine the complainant and the witnesses under oath by conducting searching questions. Okay? The court explained that the Supreme Court said that the argument, that the Constitution now required that the judge personally examine the complainant and his witnesses in his determination of probable cause for the issuance of warrant of arrest is not an accurate interpretation. That is not the correct interpretation. Okay? The Supreme Court said, the constitutional provision does not mandatorily require the judge to personally examine the complainant and his witnesses. Instead, he may opt to personally evaluate the report and the supporting documents submitted by the prosecutor, or he may disregard the prosecutor report. Okay, the argument that the Constitution now required the judge to conduct personally, an examination, need to conduct personally by himself and examine the complaint and the weaknesses in the determination of probable cause is not an accurate interpretation. So that is the case of Sullivan versus Macashier, no? A well-known columnist. Now, let's go to the method of arrest. We have now warrant of arrest. How it will be implemented. When a warrant of arrest is issued by a judge, the warrant is delivered to the proper law enforcement agency for execution. The head of the office to whom the search warrant, the warrant of arrest was delivered, shall cause the warrant to be executed within 10 days, class, from its receipt. So he should execute that within a period of 10 days. Now, within 10 days after the expiration of the period, the officer to whom it was assigned for execution shall make a report to the judge who issued the warrant. So, if the warrant of arrest was not implemented within a period of 10 days, then he shall make a report. Okay? In case of failure to execute the warrant, he shall state the reason for the non-execution. So that is the principle. You need to make a report, okay, for your and as well as the reason for your failure to execute the warrant. When making an arrest by virtue of warrant, the officer shall inform the person to be arrested the cause of his arrest and the fact that a warrant of arrest had been issued for him, that the information need not be given when the person to be arrested flees, forcibly resists, or giving the information will imperil the arrest. I repeat, you need not give or furnish copy of the information to the person to be arrested when 1. He flees, he tried to escape. 2. Or he's an escapee. 2. He resists or forcibly resists. 3. The giving of the information will imperil or endanger the arresting or endanger the arrest or the arresting officer. So that is the principle where you need not furnish or give him copy of the information. The basic rule in case of implementation of a warrant of arrest is that no violence, okay, must be used. No need for the use of violence, okay, so that you will not be charged for violation of the what we call anti-torture, or what we call this, the violation on the right of the accused under 1748. An underlying rule governing arrest is the prohibition against the use of violence or unnecessary force in making the arrest. The rule emphasizes that no person arrested shall be subject to a greater restraint than that of necessary for his detention. Sir, assuming that the person I'm going to arrest is bigger than me, he's more of strong body built than me, can I ask assistance from other person? Yes, you are allowed to do that, class, under Section 10 of Rule 113 of the Rules of Court. The duty of the person summoned does not arise when rendering assistance would cause harm to him. So when person to be arrested inside a building, then another principal class, you have the power. Okay? If the person to be arrested or is reasonably believed to be within any building or enclosure, the rule authorizes the officer to what? In order to make an arrest, to break into, okay, breaking into the building or enclosure if he is refused admittance thereto after announcing of his authority and purpose, class. After entering the building or enclosure, he may break out from said place if necessary to liberate himself from the same place. So this is the principle of what we call breaking into the building or breaking out from the building in order to liberate himself. Breaking into the building to effect arrest, and breaking out from the building to liberate himself, class. So no issue as to warrantless arrest, okay, because they are already been, okay, has been expressly provided. So but for purposes of a matter of recall or memorization if you want to, class. Here, when in his presence the person to be arrested has committed, is actually committing, or is attempting to commit. Okay, this is the principle of flagrante delicto. Then, number 2, the principle of probable cause or personal knowledge. Okay, when an offense has just been committed, and he has probable cause to believe, and based on personal knowledge of facts and circumstances, that the person to be arrested has committed it. And letter C, class, that the person to be arrested is a prisoner who has escaped from a penal establishment or place where he is serving final judgment, or temporarily confined while his case is pending, or has escaped while being transferred from one confinement to another. So these are the instances of what we call warrantless arrest. Well, who may make the warrantless arrest? Well, under the principle, it's the police officer, as well as we have the principle of citizen's arrest. Okay? So you know that principle under the Rule 113 of the Rules of Court, class. A peace officer or private citizen may, without warrant, arrest a person when in his presence the person to be arrested has committed, is actually committing, or is attempting to commit an offense. This is known as what we call flagrante delicto. The arrest made by a private person under the circumstances provided for under rule is usually called citizen arrest, class. So, flagrante delicto, okay, that is the basic principle that we have. Now, there is no much issue about flagrante delicto, but the principle is the probable cause and personal knowledge. Okay? In short, the principle of hot pursuit operation. Okay, what is a hot pursuit operation? When an offense has been committed and he has probable cause to believe, based on personal knowledge of facts and circumstances, that the person to be arrested has committed. So, the second instance of lawful warrantless arrest, okay, covered by paragraph P, cited, okay, two stringent requirements before a warrantless arrest can be effected. Number 1, that an offense has been committed. Number 2, the person making the arrest has 1, personal knowledge of the fact and circumstances that the person to be arrested has committed it. He himself has personal knowledge that the person to be arrested has committed it. This exception does not require that the arresting officer or person to personally witness the commission of the crime. In fact, the offense was not committed in his presence, although said offense, as required by the rules, has been committed. The tenor of the rule obviously emphasizes the immediacy of the warrant of the arrest reckoned from the commission of the crime, class. So, what is important in a hot pursuit principle is the principle of immediacy, okay, between the time of the commission of the offense and the time of arrest. And this principle is what we call in a case-to-case basis. Let's have this case. An arrest made based on information from an unnamed source a day after the crime is committed is considered as invalid. Okay, just one day has lapsed. Another, the accused was arrested 6 days after. Okay, after the commission of the crime. The same was invalid. Okay, because the crime is no longer has just been committed. Now, the principle on personal knowledge, okay, under the hot pursuit operation, does not refers to actual knowledge, means you have actual knowledge of the commission.